5, 4, 3, 2, 1. We noticed that the administrative committee, in its report, had adverted to the entire service record, including the pending disciplinary inquiry regarding integrity of respondent number 1, full stop. It is settled position in law that the competent authority is supposed to consider the entire service record of the judicial officer, and even if there is a solitary remark of lack and breach of integrity, full stop. Contention of the learned counsel for the petitioner was that once the result had been declared on 3/4/2020, the returning officer became functus officio, therefore, he could not have cancelled the certificate of election issued in favor of the petitioner, nor could he have issued it in favor of the opposite party, number 6, full stop. He could not have recalled, reviewed or cancelled the certificate of election already issued, that too, without any wherein, it has been held that once the result of election is declared, then, the returning officer and the election commission become functus officio and cease to have jurisdiction over the elections, full stop. They cannot cancel the declaration of result or direct fresh poll, and it is the election tribunal alone which is competent to deal with the dispute arising out of or in connection with the election, full stop. The election commences from the initial notification and culminates in the declaration of a return of a candidate, full stop. Election process, thus, comes to an end on the final declaration of returned candidates, full stop. Learned counsel also relied upon Article 243-O of the Constitution of India in support of his contention, full stop. Learned counsel for the petitioner placed heavy reliance upon a document annexed as Annexure SA-2 with its affidavit dated 4/4/2020 by the Election Commission to contend that the election process was over, and the same was notified on 5/4/2020 as per the Election Commission itself, therefore, the cancellation of the certificate of election issued to the petitioner on 7/4/2020 is erroneous in law and without jurisdiction, full stop. The legal position, no doubt, is that ordinarily there would be no interference in an election matter after an election result has been declared, however, we find that on 3/4/2020 itself, the petitioner had submitted an application before the ARO/RO pointing out the error, but, the said officer did not apply his mind to the facts before him, full stop. Had he done so, this situation would not have arisen, full stop. It is also a question before us that should we ignore an apparent illegality which has not been rebutted by the petitioner in spite of opportunity before us, and thereby should we revive an illegality by interfering with the order on the grounds asserted by the petitioner's counsel, full stop. We have to keep in mind that we are exercising equitable discretionary jurisdiction under Article 226 of the Constitution of India, and if a fact is apparent and the impugned order has done substantial justice in the matter by rectifying the error, which is apparent and remains unrebutted, then, the High Court under Article 226 of the Constitution of India would not interfere, as, in doing so, it would revive another illegality, full stop. इस वीडियो के डिस्क्रिप्शन बॉक्स में टेलीग्राम चैनल का लिंक दिया हुआ है, जहां पे आपको ये PDF प्रोवाइड किया जाएगा.